Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there and welcome once again to Ask a Lawyer. Thank you for joining us here on CP24. John Scholes, I'm your host, and my co-host is going to be on screen in just a moment. Employment lawyer Lior Samfiru. I'll tell you right off the hop how you get a hold of Lior and his team. Always inviting your calls, always capable to help you anytime with any of your employment law matters. 1-888-861-4555. Email is ask@employmentlawyer.ca, and just employmentlawyer.ca is a good website you want to go to. I'll mention pocketemploymentlawyer.ca. That's going to come down, at least we're going to mention that a little later on in the show, and why. There's a number of good tools for you to use. It's free and it's anonymous, but we'll get to that just a little later on in the show. The basic wide open topic for this week is going to be, Lior, what should I do? There's a million questions. We'll probably get 5 or 6 on this show over this half hour, so stay tuned for those. And we're going to get to all that in just a bit, maybe a couple phone calls from our long-running radio show, which, by the way, you can catch us Sundays, among other stations across the country, on News Talk 1010, Sundays at 1 p.m. But, Lior, we always start off, we get our employment law muscles flexed a little bit with something that's been going on in your world, pal. What do you got for us today, sir?
Well, I talk employment law on the show, in the office, all the time, and that's what I like, that's what I do, and I want to have this opportunity, like I do every week, to inform and educate our viewers. So if this is the first time our viewers are listening, you're in for a treat, I hope, because you're going to be some of the more rare people that know about workplace rights, that know about employment law, that know what to do if you're facing a problem. Whether you lost your job, you're dealing with your severance, harassment, discrimination, bullying, you name it, we talk about this on this show. So if this thing ever happens to you or someone that you know and love, you'll know what to do, you'll know what to say, and you're not going to have to run out to Google and try to find a solution. This is the opportunity to get that information. And of course, if you want to continue the discussion beyond the show, if you want to reach out to me and have myself or my team actually help you resolve those workplace issues, we'll give you that contact information throughout the show, so stay tuned for that. But I always like to start with what I call the week that was, a case that came across my desk. Now, I've spoken before on the show about the duty to accommodate. And oftentimes that happens when someone is unable to do their job. Maybe they're coming back from a disability leave and the employer has to provide that help, that accommodation, that support. Well, I had a matter that dealt with the duty to accommodate, but in a bit of a different context. And I thought it was important to mention it here. So I spoke with a gentleman that recently was offered a promotion in his job. He was very excited about it, told his employer that he wanted it. Well, before that promotion was made official, his employer asked his doctor to fill out a form, just ensuring that there's no limits or asking if there's any physical limitations. Well, this gentleman had some physical limitations. He didn't feel that they were particularly relevant to the job. When his employer got that letter from a doctor, they said, well, no, this would require some accommodation. We're not willing to do that, so we're going to have to pass you over with respect to this promotion, and we'll see down the road what we do. So he was very upset, of course. I think anyone would, and he called me, and he wanted to know what his rights were in this particular situation. So here's the thing. He had to be accommodated. To the extent that his employer could allow him to take the job with accommodation, they had to make it happen. It wasn't a choice. It wasn't an option to say no. They had to accommodate. That may mean helping him if there's tasks that he can't do, providing additional support. They had to do it. And that failure to accommodate was a human rights violation. It's illegal. So here's what I'm going to do for him. I'm going to send a letter to the company. And once they hear from me, John, I bet you anything that the wheels will be in motion to provide that accommodation, because they know we called them on it. So if this sounds familiar, if you have limitations and your employer won't accommodate you, you have to give a call.
Again, a call or quick email, ask@employmentlawyer.ca or just employmentlawyer.ca, as I mentioned off the top, to find a radio station pretty much across the country, which will you can tune into and catch our weekly radio shows. We get some great calls. People call in, they want to know things, stuff you learn on this show every week. So we take those calls, we play them back, Lior, and we talk about them. Our first phone call for the radio show is coming up right now.
I've been employed with a large employer for 8.5 years, and through a restructuring, they gave me my walking papers last week. I'm 65.5 years old. I was a manager, and they're offering me 32 weeks. And I've been listening to your show a number of times, and that seems pretty inadequate to me. They gave a date that I have to get back to them by.
Well, I love getting calls like that, John, because he listened to the show, and by listening to the show, he knows that what he's offered is not adequate, and it's not at all. Now, before I even talk about that, let me mention that deadline that he has there. Every severance offer has a deadline, and it's a pressure tactic. He knows, because he watches the show, not to fall for that pressure tactic. Same with you at home. If you lose your job, you're getting that severance letter, that deadline is meaningless. They're trying to pressure you to accept less than what you're owed. Now, we know that this person was offered 32 weeks, call it 7.5 months after 8.5 years of service. That's kind of almost a month per year. And a lot of people may say, that sounds pretty good. Well, it's not. It's not even close. So I'm going to show you how to find out how much he's owed, how much you're owed if you lose your job. I'm going to use our severance calculator tool, which you can find at PocketEmploymentLawyer.ca. Again, PocketEmploymentLawyer.ca. And let's see what the real amount is. We know he's a manager, 8.5 years of service, 65 years of age, was offered 32 weeks, call it 7.5 months. We see he's owed about double that, 14 to 16 months. That is what he's owed. So he's owed double what he was offered. So hopefully now we're no longer believing that it's a month per year of service. It's not that. And you can find out for yourself at PocketEmploymentLawyer.ca how much you're owed.
Great start. Let's get into a short break. Upon our return, Lior, what should I do? That's the overarching question. A bunch of emails and other phone calls have come in. We'll get to those questions in just a bit. As we get into the break, reaching out, 1-888-861-4555. Ask at EmploymentLawyer.ca. We'll continue with Ask a Lawyer. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back. This is Ask a Lawyer here on CP24. I'm John Scholes. With me, of course, employment lawyer Lior Samfiru from EmploymentLawyer.ca. Reaching out, email ask at EmploymentLawyer.ca. Phone number 1-888-861-4555. Main segment here is the question we got for today, Lior. And actually, it is a question. The topic is, Lior, what should I do? We're going to run through a bunch of questions we've got through emails, past emails, on your live streaming as well, phone calls for the radio show. We've kind of put a whole list together, so let's get right into these, pal. First one, I've been placed on a temporary layoff with no return date. What are my rights?
This is a common question. It's been a huge question over the past couple of years during the pandemic.
Totally.
So I want to talk about that. It's very, very important. So what happens in a temporary layoff, regardless of the reason, whether it's because of the pandemic, whether it's for unrelated reasons to the pandemic, you have a choice. And the choice is, you can accept it. You can stay home and hope that your employer accepts or brings you back, calls you back, or you can choose to treat that as a termination. You don't have to accept it. Your employer doesn't have the right to make the decision to put you on that layoff. So if you want it, that could be considered a termination, and you can get your full severance if that happens. The choice is yours. You don't have to wait. You don't have to wonder. You don't have to give your employer a certain period of time. If you want to do that, if you've had enough, you want to get your severance, let's connect right away.
Lior, what should I do? Number two is this. My manager is putting me on a performance improvement plan. I'm worried this will be used to fire me. What should I do?
Well, your concern is correct, because that's probably exactly what it's intended to do, to build a case against you to potentially let you go for cause. So if you're put on a performance improvement plan, if you don't agree with it, if you don't think it's complete, if you don't think it's fair or needed, I want you to say so. Okay, I want you to tell your employer about that, and I want you to make it clear in writing why you disagree with it, okay? So by doing that, you're protecting yourself. By doing that, you're ensuring that your employer can't use it against you. You don't want it to be there. Silence is the same as acceptance, and that could make it easier for your employer to let you go. Don't be rude, don't be mean, don't be nasty. But tell your employer in writing why you don't agree with it. By doing that, you're preserving your right to get severance if your employer ever considers letting you go.
Again, our topic this week, Lior, what should I do? Question number 3 is this. My boss is giving half my hours to a new, younger employee. You're like the used car. Can they do that?
Well, no, they cannot do that. Even if we forget about the younger aspect of it, your hours can't be cut. If your hours are cut in a significant way, this question is most of my hours, many of my hours, no, that can't be. That's a constructive dismissal. If your pay, your hours get cut that way, your employer cannot do that. But certainly if it's based on an age, if your employer says, well, we think this employee is younger, we want them to do the work, not you. Well, wait a second. That's age discrimination. You cannot be mistreated, let go, cut your hours for any reason related to your age, even if that's part of the reason, not the whole reason. That's a human rights violation. If that happens, there are significant consequences. The law does not look favorably on that, so definitely give me a call.
Lior, what should I do? Question number 4 is this. I'm ready to return to work from a leave of absence, but my boss says I have no job, but wants to help me get the I. He wants to help me get the I. He's a nice guy. What should I do?
You know, it seems like a specific question, but man, oh man, I get this question and variations of it every single day. So first thing is, remember, your employer has to make all efforts to bring you back if you're ready to come back from a medical leave. And if your job is truly actually not there, you're owed severance. Your employer can't just keep you on ice and say, well, just stay on the I until we're ready for you. There's no such thing. Either they bring you back or they have to pay you your full severance, which could be as much as 24 months. But also remember, if your employer could bring you back after a disability leave, but is choosing not to, that could be a human rights violation as well. In other words, it's illegal. So we really have to investigate why isn't your employer not bringing you back?
All right, question number 5. We've got one more in here of Lior, what should I do? I've been given 48 hours to accept a severance offer they claim is solid, probably not a legal term. Should I sign before the offer expires?
Well, I want you to understand that 90% of severance offers are bad, very bad. And there's never been one employer in the history of the world that gave a severance package and said, by the way, this is a really bad offer. Every employer is going to tell you it's good or it's solid. Nonsense. It's not solid. I'm telling you right now, in over 90% of cases, it is bad. The thing is that deadline, that 48 hours or 72 hours, however long, it's a pressure tactic. It's intended to make you feel like you're going to lose something if you don't sign. I'm here to tell you that's not the case. You're not losing something. The only thing you're going to do by pursuing what you're owed is get the proper amount, which could be 2, 3, 10 times more than what you've been offered. That's why we have EmploymentLawyer.ca. That's why you give me a call, so that you don't accept inadequate severance.
Again, the website, EmploymentLawyer.ca, the place to go to find a radio station to catch our 1-hour radio show weekly, including News Talk 1010, Sundays at 1 p.m. You'll catch that. And we'll get to our second phone call, Lior, from the radio show right now.
An employee is sick for 2 years and is on long-term disability. Is the employer able to terminate that employee while on long-term disability, and what does that entail?
There you go.
So it's always a problem when an employer wants to let go of an employee that's on a disability leave, because right off the bat, it could be a human rights violation. The only way to do that legally is if the situation is what we refer to as frustration of contract. For that, 2 things have to happen. Number 1, the employee would have to be gone for a long period of time. 2 years is a long time. But beyond that, there has to be some information that that employee won't be able to come back to work. Okay? So it's not enough to say, well, you've been gone for so long, we can terminate. No. Gone for a long time, let's say 2 years or more, and also evidence, medical evidence that that employee will not be able to come back to work. If both of those conditions are met, then and only then can the employer let go. Now, in a frustration of contract situation, the employer won't have to pay full severance. They'll have to pay only the minimum severance, which is less, but still some severance. But John, I have seen many times, employers saying, no, this is a frustration of contract situation. We can let go, without them actually being able to do that, without them being able to show that that employee will not be coming back to work. So if your employer lets you go when you're on disability leave, even more important than ever that you give me a call.
We'll take a short break, get back into more. In fact, when we come back, what happens when you're reclassified as an independent contractor and your rights working for an American employer. We'll cover that off as well. In the meantime, 1-888-861-4555 and ask at EmploymentLawyer.ca is how to reach out to Lior. Lots more of Ask Lawyers coming right up. Stay with us.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back. This is Ask a Lawyer. I'm John Scholes. With me again, Lior Samfiru, employment lawyer at EmploymentLawyer.ca. To reach out, 1-888-861-4555, ask@EmploymentLawyer.ca. And just EmploymentLawyer.ca is the place to go. Those radio shows we keep talking about, and we do them across the country, including right here on News Talk 1010, Sundays at 1 p.m. Phone call number 3, Lior, from the radio show is coming up at you right now.
I've been working for 11 years now, and I've noticed that I was originally hired as an employee, and as of this year, I'm now registered as an independent contractor, and they're cutting my hours. I really feel that I'm being treated unfairly and that I have more seniority than anyone else in the company.
So this is a case that brings up the issue of contractor versus employee. So the way I'll say it this way, John, you don't become a contractor magically after you've been an employee already. So this person says, for years I was an employee, now somehow magically at one point I became a contractor. It doesn't work that way. He's been misclassified. If you were an employee once, you're probably still an employee now, unless something major has changed. You do your job very, very differently. And that distinction between employee and a contractor is extremely important because employees have employment law rights, contractors don't. And that also means if you are truly, and this person truly is an employee, and by the way, he is, then he can't have his hours cut. He can't have his pay reduced because that's a constructive dismissal. Constructive dismissal, of course, is when your employer changes the terms of employment in a significant way, which results in a termination of employment. That only applies to employees. It does not apply to contractors. So if I'm right, he's an employee. Number 2, this is a constructive dismissal. Number 3, then the question becomes, okay, what is he owed? If he's been constructively dismissed because what his employer is doing, how much severance should he be getting now? Remember, he's an employee, not a contractor. Well, I'm going to show you exactly how to find out how much he's owed, how much you're owed. If any of this sounds familiar, simply go to pocketemploymentlawyer.ca, use our severance calculator, and let's use that right now and see what that gives us. So this person is in a clerical role, been there 11 years, 52 years of age. He's not a contractor, he's an employee, and you see right on the screen, he could easily be owed his 10-month severance, and John, I think that's even conservative. He could be owed more than 10, 12 months, 13 months of severance. So that's why it's so important to understand that distinction between employees, between contractors. So many people are misclassified. If you're not sure if you're one of them, you give me a call.
Yeah, you can make that phone call anytime or you ask your questions. Simply ask at EmploymentLawyer.ca. I thought this was a good one to bring up here, Lior, because it talks about working in the U.S. or working for a U.S. employer. It says, my brother just lost his job. When he asked about his 2 weeks' pay, his manager said he would look into it, but it likely wouldn't apply because the company's based in the U.S. and their laws are different.
So I get this all the time, and I laugh because really those companies should know better than that. So here's how it works, and it's actually incredibly simple. The laws that matters are the laws of where you're physically doing work. If you work physically in Ontario, that's the law that applies to you, the laws of Ontario. It doesn't matter where the company is headquartered. You may be working from home in Ontario, but the company is in the state of California. It doesn't matter. It's the laws of Ontario that apply to you, and that's important because you have rights then to overtime, vacation pay, and of course, severance. Now, interesting, this person asked for his 2 weeks, except he's owed a lot more than 2 weeks. It could be 24 months. So no, don't ever believe that the company's telling you, no, our laws are somewhere else, whether it's in the US or a different country. That's irrelevant. It's the laws of where you're working.
Coming up, when you've been asked to sign an employment contract after you've been hired, right? We'll tackle that after a short break. The number to reach out to Lior and crew, 1-888-861-4555. Email ask@employmentlawyer.ca. We'll continue. This is Ask a Lawyer. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back. Thank you so much for sticking around with the remainder of the show here, Ask a Lawyer on CP24. In addition to being a lawyer, a radio show, a TV host, a father, a million other things. Lior also does a ton of live streaming on YouTube and Facebook. He has time actually to do these things. We get a lot of great questions on those. You want to take part, go to @STLawyers, @STLawyers to take part. The number 1-888-861-4555 to reach out by phone and ask at EmploymentLawyer.ca. Lior, I want to get to this final question. It says, when I was hired a year ago, I was told I would be given an employment contract to sign, but it never happened. With my employer remembers down the road and asked me to sign one. What do you do?
Well, the first thing I'm going to say is be very grateful that you haven't signed one.
Right.
For an employee, I want to be very clear. For an employee, you're better off not having signed an employment agreement. Walking in, handshake deal, something on the back of a napkin, that's what you want. That's much better than having that 10-page employment agreement. So be very grateful for that situation. That employment agreement often just takes away your rights. But what if the employer realizes that and says, well, now I realize I forgot, I want you to sign an employment agreement. Well, you can't be made to sign the agreement at that point. You cannot, and in fact, you should not. You can tell your employer, I'm fine with what we have, I don't want to sign it. And could your employer let you go? Maybe, but they would have to pay severance. You don't want to sign an employment agreement that could limit that severance. Best advice, call me, I'll tell you what it says, and then at least you'll know.
Great stuff for another week. Thank you so much for tuning in. I want to remind you one more time across the country, but specifically right here, you can catch our weekly radio show on News Talk 1010. Happens Sundays at 1 p.m. All kinds of opportunities for you to reach out, call the show. Your call may end up on air, maybe not, but they can always deal with it. And also CP24, you'll catch this show, Ask a Lawyer, cp24.com/askalawyer. Wednesdays, of course, at 9:30. And beyond that, 1-888-861-4555, the phone number and the email, ask@EmploymentLawyer.ca. We'll catch you next time on Ask a Lawyer. Thank you so much for sticking with us.